technically not in custody.
Gentlemen, we are on Zoom. We are live. I'm sorry.
My head's cut off.
You sure are. I'm sorry. I'm trying to figure out who that is. It's gonna be on block. Try that. There we go. And you can read it if you need to. Good. Mr. Rhodes? Yes, okay. Mr. White? Thank you.
This has already been turned into the court, so this is not.
And this,
And that's the fingerprint we were done, and the state already signed that one. The state has not signed that, and needs a fingerprint.
this man, I'm gonna feel.
They were doing the grant.
Thank you, Dakota. That's, you have a bookend sheet that the deputies fill out when they arrest somebody. That's one of sheets. Thanks. You said you're aware that the states was concerned.
Right.
Is this
So
one?
I don't know what happens if you take it back and then the state comes over to the courthouse. I would have gotten one of them signed, they didn't have that set ready when I had the other one signed by them yesterday.
Thank you, sir. That's what I need. This is the point. Yes, sir. That ought to take care of it. Thanks, Mr. Deputy. I'll step up here, Ms. Beasley. Let me make sure I can get. I think there's been a problem with volume in the past. Yes.
See whether. citizen. Because he didn't realize you could see him. One of them.
Right. Just one person.
Didn't have a phone. I mean, it's. I'm gonna have to get back.
Oh, good.
But I love that advice now. I'm gonna have to go back to the office to check on that. Well, if we set you another 30 days, you'll feel. Yeah, probably. No, I'm just telling you.
Could you come over here with me for a second, please? As soon as he starts, I'll get you to sit back down. You don't know what that is. And you don't have to. Okay.
I could see you have a zero.
Aaron?
Okay.
Good afternoon, Ms. Beasley.
Good afternoon, Judge.
You have good Christmas?
Yes, sir. And you?
You got retirement for Christmas, so that's a great gift, isn't it?
That is, Judge. Definitely.
Well, do we have any of your clients ready to go this afternoon?
Both of them, Judge. Mr. Walker and Ms. Halford.
All right, who do you want to go on first?
Mr. Walker?
Court calls CR 2200 and CR 2232, State versus Austin Lynn Walker. This is a plea today, is that correct?
That is correct, Judge.
All right, Mr. Walker, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Make sure during your testimony today that you speak up loudly and clearly so that I can hear what you have to say and so that my court reporter can take down everything, okay?
Yes, sir.
Okay, and as Ms. Beasley just instructed you, every time you answer has to be audible because my court reporter, she can't take down a head nod, okay?
All right, yes, sir.
All right, thank you, sir. All right, Ms. Beasley, I'm looking through the plea paperwork that was submitted, and it looks like CR 2200 is going to be dismissed pursuant to the plea agreement in CR 2232. There's also another charge, a debit card, credit card abuse that's being declined due to the defendant pleading in CR 2232. And it looks like the plea agreement is that Mr. Walker is going to be pleading guilty to third-degree felony kidnapping with the DA's recommendation that upon his plea of guilt, that his sentence be set at 4 years confinement in the Texas Department of Criminal Justice Institutional Division, with him also receiving a $4,000 fine plus court costs and reimbursement fees, and Mr. Walker receiving 601 days credit towards his sentence for the time that he has spent in jail on this cause to this date. Is that correct, Ms. Beasley?
Is the fine 4,000, Judge?
I'm sorry, 2,000. 2,000. 4 years TDC and a $2,000 fine.
That is our agreement, Judge.
All right, Mr. Walker, are you a United States citizen?
Yes, sir. Sure am.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir. Sure have.
Who have you been diagnosed with?
I had a care down there in Mineola. I'm not too sure who it was. A couple years back.
Do you know what your diagnosis was?
Yes, sir.
What was that?
Schizophrenia, PTSD, and severe anxiety.
PTSD and severe anxiety?
Yes, sir.
Are you currently on any type of medication or under a doctor's care for either one of those?
Yes, sir.
You are? And do you feel like today that you're experiencing rational thought and understanding, that you can appreciate the proceedings today and understand what's going on?
Yes, sir. I understand clearly.
All right. And in this case, you are represented by your attorney, Miss Debbie Beasley. Are you pleased with her representation of you?
Yes, sir. Sure am. She's done fantastic.
I'm glad to hear that. Do you feel like you've had enough time to discuss the case with her and have all of your legal questions answered?
Yes, sir. 602 days work.
Is there anything about this paperwork that you have reviewed with her and that you have signed that you do not understand?
No, sir.
And Mr. Walker, where you have signed these documents, I'm going to show you an example. Throughout these documents, I see your signature, what it purports to be your signature. Is that your true and correct signature?
Sir, sure is.
And did you only sign these documents once you were satisfied you understood what you were signing?
Yes, sir. It took me about 2 or 3 times sometimes to read over it, but once I clearly understand, then I go ahead and sign.
Yeah, there's a lot to read, isn't there?
Yes, sir. Sure is.
And there is a lot of information in there. Do you feel like after your complete review of that and being able to ask Ms. Beasley any questions, do you feel like you understand exactly what's contained in this paperwork today and what's happening?
Yes, sir. She went over with me a pretty good bit of it, and she helped me understand it better than the way I could read it.
Okay. And you heard me ask and read the plea agreement that I thought was being done today to Ms. Beasley. And you've heard me say that, correct? That you're going to be pleading guilty to a third-degree felony offense of kidnapping. And the state or the prosecutor's recommendation is that you be convicted of that offense and that you be sentenced to 4 years confinement in prison. And you receive a $2,000 fine plus court costs, reimbursement fees, and you would be credited 601 days credit towards your sentence for the time that you've spent in jail. Is that your understanding of the plea agreement also?
Yes, sir.
All right, Mr. Walker, the range of punishment for a third-degree felony is confinement in the Texas Department of Criminal Justice Institutional Division for a period of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. That's the parameters, that's the range of punishment that your sentence must be set within to be a legal sentence. You understand that?
Yes, sir.
So sentence can't be less than 2, it can't be more than 10. I see here that the plea agreement is for 4, so that would be a legal sentence. Do you understand that?
Sure, sure do.
And the same with the fine. Okay. All right. So, Mr. Walker, understanding the range of punishment, understanding what the plea agreement is, at this time, I'm going to ask you, how do you plead to the third-degree felony offense of kidnapping?
Guilty.
And are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today?
No, sir. Not at all.
All right. And Ms. Beasley, do you believe Mr. Walker to be competent today?
I do, Your Honor.
And you have no concerns with his testimony of having some mental disorders, the severe anxiety and PTSD. You do not feel or believe that those are in any way affecting his ability to be competent today to enter into this plea?
No, sir. We did discuss those issues when I first got appointed. He's been able to see a doctor and receive medication while he's in their jail. And I completely agree that he's totally 100% competent, understands what he's doing here today.
Okay. All right. The court will accept the defendant's plea of guilt. Ms. Beasley, is there any objection to the state's evidence?
No, Your Honor.
All right. State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Ms. Heisel, are you conducting this plea on behalf of the state or is it Mr. Woodwhite?
It's myself, Your Honor.
Okay. I'd like to inquire into the victim impact statement and victim notification with regards to this plea at this time.
Yes, Your Honor. A victim impact statement was forwarded to Ms. Taberham, I believe, end of last week on this case. You've previously reviewed, I believe it's the same victim impact statement. Mr. Walker's co-defendant, Courtney Odom, pled in December. I believe it's the same impact statement. However, we would ask for you to review that before sentence is pronounced.
And is there any other information from the victim that the court should be aware of before considering the plea agreement?
No, Your Honor, I don't believe so.
Okay. Take just a moment and review the victim impact statement. All right, the court has reviewed the victim impact statement form that has been provided to the court. Ms. Heisel, on behalf of the state, is there anything further?
No, Your Honor.
Ms. Beasley, on behalf of the defense, anything further?
Yes, Your Honor. I'd ask that my client be allowed to testify.
Yes, ma'am. You may proceed.
State your name for the record, please.
Austin Lynn Walker.
Austin, I was appointed to represent you on an aggravated kidnapping case. Is that correct?
Yes, ma'am.
And during that process, you and I have spent many, many hours visiting at this jail, going on all the information contained in your police report, warrant affidavits, also any DVDs that were available, CAC interview with the victim. But we've gone all over that multiple times. Is that correct?
Yes, ma'am.
And you and I've gone through the pros and cons of this case about whether or not to try the case or to do a plea. And even from the beginning, we figured out together that this needed to be a plea. Is that correct?
Yes, ma'am.
So we spent all this time going over the information, but we also were trying to get the case resolved to the best that we possibly could for you. Is that correct?
Yes, ma'am.
And this is what we were able to get worked out for non-aggravated years in PDC on kidnapping. Are you satisfied with that?
Yes, ma'am. Sure am.
Is there anything you would have wanted me to do that I did not do?
No, ma'am. You did everything you could do, and I appreciate your time.
Thank you. Pass the witness.
Any
No
questions?
question.
Okay, thank you, Ms. Heisel. All right, the court has reviewed the evidence in this case. Court finds that it should follow the plea agreement between the state and the defendant. Court hereby convicts Austin Lynn Walker of kidnapping, a third-degree felony. Court assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Assesses a fine at $2,000, court costs of $290, and reimbursement fees of $20. Court will award Mr. Walker 601 days credit towards his sentence for the time that he has spent in jail on this cause. Court also, as previously stated, is granting the state's motion to dismiss in CR 2200. And the court notes that the state has declined for prosecution credit card or debit card abuse with an alleged date of April 25th of 2020. Mr. Mr. Walker, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, sir.
Thank you.
Deputy McLeish, he's already been fingerprinted and I have all of that. In case you weren't aware.
Thank you, sir.
You're welcome. All right, Ms. Beasley. You said Ms. Halford, is that correct?
That is correct, Judge.
All right, Ms. Halford, this is cause number CR 21325, State versus Hannah Nicole Halford. We're set for a plea today. Is that right, Ms. Beasley?
Yes, Your Honor.
All right, and Ms. Halford, if you could just raise your right hand, I want to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
You.
All right, you may put your hand down. Make sure during your testimony you speak up loudly and clearly so I can hear you and so my court reporter can take it down, okay? And Ms. Beasley, I'm not aware of what the terms of the plea are. Can you recite those to me?
Yes, Your Honor. We're entering a plea to a state jail felony offense of abandoning or endangering child by criminal negligence. The DA's office has offered 6 months state jail time, $1,000 fine, no restitution. Court cost is $290. Reimbursement fees, $35. And back time credit is 3 days.
Any 1245s or other dismissals? Or is this the only charge?
This is the only charge.
All right, Ms. Halford, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, I have.
What have you been diagnosed with?
Major depression disorder, PTSD, and anxiety.
Are you currently on any type of medication for those?
Not right now because I had a little complication with my medicine, and they're trying to fix that right now.
Okay, so you're under a doctor's care at this time? But you're not currently on your medication, is that right? And I'm sorry, I think we're just having a little bit of technical difficulty here in the courtroom. Did you say that you are under a doctor's care,
Yes, sir.
but you're not on medication at this time?
I'm not.
Okay. Do you feel like the fact that you're not on your medication today is in any way preventing you from being able to understand what's going on here today?
No, sir.
So you feel like you've got a sound mind and understanding today?
Yes, sir.
And in this case, you're represented by your attorney, Miss Debbie Beasley. Are you pleased with her representation of you?
Yes, I am, sir.
You feel like you've had enough time to discuss the case with her and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed with her and signed today that you do not understand?
No, sir.
And everywhere that you signed, are you telling me that that's your true and correct signature and that you only signed once you were satisfied that you understood what you were signing?
Yes, sir.
You heard Miss Beasley tell me what the plea agreement was. Is that your understanding of the plea agreement today?
Yes, sir.
All right, Ms. Halford, you are charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. A state jail felony carries a range of punishment of confinement in a state jail of not less than 6 months or more than 2 years, and a fine not to exceed $10,000. Any sentence by way of a plea bargain or a sentence handed down by a court or a jury must fit within that legal range of punishment. You understand that?
Yes, sir.
And so you understand what the range of punishment is, and you understand what the plea agreement is. And I see here that the plea agreement does legally fit within that range. So at this time, I'm going to ask you, how do you plead to abandoning or endangering a child with criminal negligence?
Guilty.
Are you pleading guilty to that crime because you're guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
Court, well, let me, before I accept her plea, Ms. Beasley, do you feel like Ms. Halford is competent today?
I do, Judge. We've been able to discuss the case ask logical, rational questions about the legal process in her case. So I do believe that she is legally competent today to do her plea.
And it's my understanding that you have represented her at times when she's on her medication, and you've had interactions with her today, and probably maybe other times where she's not been on her medications. Do you have any? I know what the answer is. I know that if you had cause for concern, you would inform the court as such. But can you assure me today that you have no concerns with her not being on medication today?
I have absolutely no concerns, Judge. Based on how she's presented herself and the questions she's asked, I do believe 100% that she is competent.
All right, thank you. All right, the court will accept Ms. Hawford's plea of guilt. Ms. Beasley, any objection to state's evidence?
No, Your Honor.
All right, state's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, and if I could just have a recitation of the facts to support the plea.
Yes, Your Honor. Grand Saline PD, in the month of July, back in 2021, July 2021, sees a 2-year-old and a 3-year-old barefoot with no clothes on except for dirty diapers, walking down the side of Highway 80. The officer pulled over. He just happened to know Miss Halford and her children. He was able to put the children in his patrol vehicle and proceed back to Miss Halford's residence. When he arrived at the residence, he saw the front door standing ajar, and Miss Halford was inside asleep. They were able to wake her, and then based on the neglectful supervision of the children and their respective ages and weather conditions, CPS intervenes. These criminal charges were brought. Judge, that's my recitation of the facts. I also have a CPS update if the court wants to entertain that as well.
Yes, please.
Your Honor, the CPS case is still pending. Ms. Halford has worked some services. However, CPS does have some concerns. So I don't anticipate that will be resolved quickly. But I have talked to our CPS attorney about the resolution proposed here and agreed to all the parties, and CPS is on board with that as well.
Thank you, Ms. Beasley. Ms. Beasley, any objection to that recitation?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, then based on the evidence presented to the court will follow the plea agreement and the recommendation. Court hereby convicts Ms. Hannah Halford of abandoning or endangering a child with criminal negligence. Court assesses her sentence at 6 months confinement in the State Jail Division of TDC. Court assesses a $1,000 fine, $290 court cost, and $35 reimbursement fees. And the court awards her 3 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Halford, I'm going to remand you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with my deputy to be fingerprinted. Good luck to you.
Yes, sir. Thank you.
You're welcome. Hello, Mr. Gimbel.
Afternoon, Judge.
You have Mr. Barentine with you?
Yes, Mr. Barentine is here and we are set to plea this afternoon. I am confident that Mr. Barentine is satisfied with the terms and conditions of the offer in the state's plea. He has been unable to communicate all the terms, and his particular concern is with the commitment of the fine. And I would just ask the court if we could set this off to the next possible plea setting. I'm confident this will be resolved.
Yes.
And give me the opportunity to visit with the state and confirm that we are in fact locked in with the time and fine, and allow Mr. Barentine the time to visit with his family
I just need to contact my family. Yes, sir.
and provide signatures.
Did you say, Mr. Gimbel, that there's a concern about the fine? Is that what you said? Or did you say time?
The time and the fine, he is satisfied with the conditions offered by the state.
I just need to call my family.
Okay. Did we previously appear in the case and set this for a plea, or did you set it for a plea?
I was appointed on the felony, and then later he was arrested on 2 misdemeanors that Miss Abraham appointed me on. And when we resolved this matter to resolve both the felony and both the misdemeanors, this is our first setting for a plea hearing. And Miss Abney provided me the plea paperwork. It was 4 o'clock yesterday evening. And so it was this morning before I could visit with Mr. Barentine.
Judge, this case was set for pretrial on Thursday and was reset for a plea because we reached an agreement. I believe this is our first plea setting. State would have to take no position on resetting for a short period of time to allow Mr. Barentine whatever communications to consider the case, whatever he needs.
Do we want to come back on Thursday?
I need a little more time. If I could have more time to correspond with my family, would be better for me, please.
And how much time do you need to speak with your family about whether or not you take a plea?
A month at most, maybe less than that, if possible. I need to situate a parole address and whatnot, and situate all my affairs before I go.
All right, give me just a second. Let me review your case real quick. Hang on.
Yes, sir.
All right, so we were set for pretrial this coming Thursday, and then y'all scheduled it for a plea. But you're telling me that y'all don't have an agreement, really.
So I like the agreement. I just need time to correspond with my family.
I understand. Mr. Barrington, I guess what I'm confused about is why are we having this hearing today?
I wasn't aware of the bargain being struck and gone through until this morning. They didn't get the paperwork until yesterday afternoon.
Mr. Gamble, do you have any contested pretrial motions?
No, it did not, Judge.
So I'm going to say that today is now our pretrial hearing since it was set for Thursday and we removed it. So today I'm going to find that there are no contested pretrial motions. And I'm going to set you for a docket call on February 10th.
Thank you, Judge.
All right. So you'll need to do a notice of setting from there, Mr. Gamble.
I like the bargain. I just want to correspond with my family.
I understand. I don't want to set things for plea and have everybody jump through hoops and then be told I'm not ready to go. It's just a waste. Honestly, it's just a waste of our time. Okay.
I'll correspond with my family.
That's okay. No, I'm giving you what you want. I'm just telling you why I'm confused. Okay. So fill out the notice of setting, have him sign for February 10th, and we'll come back. If he wants to do it on that day, great. If he doesn't, then we'll set for trial.
Thank you, Judge.
You're welcome, sir.
And Your Honor, will that be at the jail call on February 10th?
It will be at 1:30.
I apologize for the waste of time to the court.
It's okay.
And Your Honor, that is all I have this afternoon. May I be excused?
Yes, sir. Thank you. Ryan, are you ready on Mr. Robles?
Yes, sir, I am.
All right, this is cause number CR 16557, State versus Oscar Francisco Robles. And I had it, Mr. Robles set, he indicated that he was going to retain an attorney. And Mr. White, you're here, so I'm assuming that you've been retained by Mr. Robles.
I was retained yesterday, Your Honor, so I don't even think we've got discovery yet.
All right, and I understand that you filed a motion to transfer.
I did, Judge. My understanding was that you may have been the prosecutor on this deal at some point. So we went ahead and just trying to get ahead of everything, went ahead and filed a motion to transfer it. So that's kind of.
Yeah, Mr. Woodwalker, Ms. Heisel, can you just take a cursory look into the file and see if there's, Mr. Robles' name doesn't stand out to me, but that doesn't mean anything. I know that Judge Winters was defense counsel for Mr. Robles, so I don't think that you'll get a motion to transfer. It would be if I was the DA, if I was an active prosecutor in this case, then I would have to do a disqualification and we'd have to get a visiting judge appointed. But I think Ms. Taberham did a review in our system and found that Judge Winters was counsel at one time for Mr. Robles back, I think, in 2016 on this case.
I'm reviewing, Judge. I don't believe that you were an active prosecutor. I will turn over as all of my discovery to Mr. White. He can do a further review, but my quick review does not show any notes that you have made any notes. You were, it appears as though it was Mr. Schmidt and then it was Miss Curry. It was Judge Winters was the defense attorney for at least some time. I do not see any notes or indications that you were the prosecutor, took any sort of active role in this particular case.
Judge, that's fine. If Mr. said you weren't on there, then we're good to go. We don't need to transfer.
Okay, well, let's do this. If Mr. Woodwike, if you would just do a thorough due diligence check on that, if that comes to light.
I will do that as soon as the court is done. This court is done today, hopefully, or maybe first thing in the morning. And I will let Mr. White know if I find anything. And if I do find something, I'll obviously notify the court. If not, we will proceed as though you are not, Judge.
Okay. And obviously,
Your Honor, if Mr. Woodwike wants to email you and just tell you, or your court or your staff, I'm fine with that. I don't care if he contacts the court without me knowing about it.
okay. Well, you both know my policy. If I was an active prosecutor on that, if I don't have knowledge of it, but there's any evidence of that in the state's file, then I'll just do a voluntary recusal. And if that's the case, and since I already know that Judge Winters at one point in time was counsel, then he would obviously be recused as well. And so if that does happen, then I would just do a voluntary recusal disqualification and we'd have a judge appointed. But you'll let me know if that happens. I'm trying to look to see what Mr. Robles' his last setting was on this case. Let's see. Yeah, it looks like Judge Winters withdrew back in December of 16, had filed several motions to suppress, a bunch of things. I'll tell you what I'm going to do. And then it looks like Mr. Sickle then became counsel for Mr. Robles. He filed several motions as well. So I think what I would like to do, due to the length of time that it's been since he's been in court, is let me set this for a pretrial for you, Mr. White, so that you, being a new attorney to his case, will have time to review the evidence, and then you can adopt any motions they filed or file your own motions. That way, kind of get a clean start for you. So let's look at what about February 10th? Do you think that would give you enough time?
Judge, I'll do everything I can to be ready by that time.
Okay. All right. So we'll set Mr. Robles then for pretrial on February 10th at 1:30, 9 a.m. if he's on bail. All right. For the record, Mr. Schmidt is ill today and unable to appear via Zoom. I don't know if any of his clients are do we have any of his clients pulled? Okay. So for the record, we are going to reset all of Mr. Schmidt's clients until Thursday. So maybe if we just send a message back to them that they were expected to be in court today, he's going to try to be available on Thursday afternoon. So that's CR 17397 Ryan Augustine, CR 21276, and then CR 21-78 and 79, Daniel Scott Larsey. And then CR 2367, Amber Joe Smith. We'll reset all of those for the same settings that they've already had scheduled for today for Thursday the 6th. All right, do we have Mr. Ashmore, Mr. Craddock's clients? Do we have Teresa Lopian or Kareem Miller available?
Yes, Your Honor, we have them both available.
Excellent. All right. Mr. Craddock, are you still there, sir?
Yes, Your Honor, I am.
Oh, excellent. Thank you, sir. All right. You care which one we call first, Mr. Craddock?
Your discretion.
All right. Ms. Lopian, if you'll come up, please. Mr. Craddock, do you know if I show that Ms. Lopian is set for arraignment today. If that's correct, do you know, have you had an opportunity to go over the indictment with her at all?
Not me personally, Your Honor.
All right. I'll tell you what, give me a second and I will pull this up and we'll get this displayed to her. Lopian, can you see this entire document? I know you might not be able to see the entire thing, but can you see it width-wise?
Yes, sir.
I'll make sure that there's nothing covering up, and I'll scroll down as we need. All right, so for the record, the court is having displayed CR 21-224 indictment, State of Texas versus Teresa Jean Lopian. So I'm going to give you just a moment, Ms. Lopian. Do you read and write?
Yes, sir.
Okay, all right. I'm going to give you a moment to just read through this, and then we're going to ask you some questions, okay? You can tell me when you're done, okay?
I'm finished, sir.
Okay. All right. So, Ms. Lopian, it appears that the grand jury has returned an indictment. And in this indictment, is your name spelled correctly here in the body of the indictment?
Yes, sir.
First, middle, and last?
Yes, sir.
Okay. And it appears that you have been legally accused of the third-degree felony offense of intentionally and knowingly possessing a controlled substance, namely methamphetamine, in an amount of 1 gram or more, but less than 4 grams. Do you understand that charge?
Yes, sir.
And the range of punishment for a third-degree felony offense, if convicted and sentenced, is confinement in the Texas Department of Criminal Justice for a period not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
In this indictment, the state of Texas, through its prosecutors, have also alleged a prior conviction. And it's alleging that on April 30th of 2014, that you were finally convicted of the felony offense of burglary of a habitation in cause number CR 1495 in the 22nd District Court of Caldwell County, Texas. Do you understand that?
Yes, sir.
Okay. And if this prior conviction were proven at trial, then that would enhance the punishment range of the offense from a third-degree felony to that of a second-degree felony. And a second-degree felony carries a range of punishment higher than a third, which is not less than 2 years or more than 20 years confinement and a $10,000 fine. Not to any fine not to exceed $10,000. Do you understand both the primary charge and also the enhancement allegation?
Yes, sir.
All right. And Mr. Craddock, do you want to enter a plea on behalf of your client?
Yes, Your Honor. We're authorized to enter a plea of not guilty.
Okay. All right. The court will find that Ms. Lopian has been formally arraigned. And Mr. Craddock, I failed to ask, does your client waive the formal reading of the indictment?
Yes, Your Honor.
Okay. Court will find that Ms. Lopian has waived the formal reading of the indictment, has been admonished as to the charge and the range of punishment along with the enhancement. Court will enter her plea of not guilty into the record, and we will set this matter for pretrial. Mr. Craddock, do you know if Mr. Ashmore is available on February 8th or February 10th?
No, Your Honor. I think his earliest clean availability is in March.
About March 8th?
So I was just checking my calendar there. There's a special trial setting on February 8th. But a later date in February would work for us.
Later date in February. What about February 22nd?
Yes, Your Honor, that's good.
All right. Then I will set Ms. Lopian for pretrial hearing on February 22nd. That will be at 1:30, Ms. Lopian, unless if you make bail in this case, then your hearings will be held in the courthouse at 9 a.m. Do you understand that?
Yes, yes, sir.
Okay. All right. Then once you sign that notice, then we'll see you back on February 22nd. Mr. Miller?
Yes, sir.
All right, this is cause number CR 1819, State versus Kareem Bernard Miller. I show that we're set on a motion to revoke hearing today. Mr. Ashmore is not available, but he is having Mr. Joe Craddock, another licensed attorney with his firm, stand in. Do you have any announcement on this case, Mr. Craddock?
Your Honor, we are currently negotiating with the state. As for terms, we have sent a suggestion. We have yet to hear back from the state on that. We would like to request a reset for a contested hearing.
And Your Honor, I'm sorry, I didn't know that Mr. Craddock was going to be handling today's hearing. I just emailed Mr. Ashmore the state's plea offer in this case. We have no objection to being set on the contested docket. If we can work it out, we'll turn that into a plea. If not, we'll have a hearing.
Okay. And state, can you be ready on January 27th?
Your Honor, I believe we could.
Okay. And Mr. Craddock, do you believe the defense could be ready on January 27th as well?
Yes, Your Honor.
All right. Court will set Mr. Miller then for a hearing on the contested docket if there's no plea agreement reached prior to that date on January 27th. And that'll be at 1:30. All right, so the first one on the docket is Jeremy Lewis, CR 2180. Court had sent a bench warrant for Mr. Lewis at the Tarrant County Jail, and it was reported to us that Mr. Lewis had already been transported to TDC. So we'll have to execute another bench warrant and try to get him here. I'm sorry, Mr. Craddock, is that all you had today, sir?
Yes, Your Honor, if I may be excused from the room.
Absolutely, you may. I appreciate you staying in today.
Thank you, Your Honor.
You're welcome. So we'll need to track down Mr. Lewis, find out where he's at. do another bench warrant. And then we had a writ set today for Alyssa Villarreal. And Ms. Tabraham has heard from Mr. Stevens, and he is still in Kaufman County on a plea. He says it'd be about another hour. And we can either reconvene in an hour or so for her, or we could set it on Thursday and hear it at that time. How many do we have on Thursday? Not very many. Okay. 66. Oh, not in the afternoon. All right, y'all want to just? How about we just reset her? And then we can,
At the court's convenience, yes, Judge.
yeah, let's go ahead and reset her. That way we can go on about our work.
By the way, Judge, I've located Mr. Lewis. He is in the J. Middleton facility of TDCJ. Expected release date is in 2023, so he should be there for some time.
You said a J. Milton.
J. Middleton.
All right. We'll do I have Mr. Tabraham do another bench warrant, and we'll send that to that unit. You are still wanting him, right?
Yes, Your Honor.
And I'll tell you what, we'll go ahead and set him for do February 10th. February 10th for arraignment. That should give us a little over a month to get him.
And then Judge, one of us will be to the courthouse before the close of business to sign off on all those papers I'm sure we missed.
Okay, appreciate it.
Thank you.
All right, let's go. Have a good day.
Thank you, Your Honor.
You're welcome. Thank you, Aaron.